welcome to our webinar on the new flexible furlough leave. My name is Anna Christie. I'm the Chief Executive at the Sussex Chamber of Commerce. So thank you very much for joining us this afternoon. I'm joined by Dan Soanes. He's the Director and Solicitor at Sherrards Employment Law.
Thank you very much, and good afternoon, everybody. Yes, as Anna says, we're going to be talking about the new flexible furlough scheme today. The furlough scheme originally was announced on the 20th of March 2020. As I'm sure you'll remember, at that time, it was around the time that the government was putting us all into lockdown. Probably nobody or very few people had ever heard of Zoom at that point, or if they did, it was a chocolate bar. Life was changing, and this scheme was originally intended to last 3 months. It was intended to last until the 31st of May. It's been extended several times since then, but the government has now indicated that it's definitely going to end now on the 31st of October. Under the scheme as it exists at the moment and will continue to exist until the end of June, employers have been able to furlough employees and workers provided they were working for them by at least the 19th of March. But although employees could be taken on and off furlough leave, each furlough period has had to last at least 3 weeks in order for you to make the reimbursement, also to claim reimbursement from the government. If you called employees back earlier than that, then you'd have to pay those amounts yourself. You wouldn't be able to claim anything back from the government. As of the 1st of July, that's the main thing that's going to change. After that, employers will be able to furlough their employees flexibly. And what that means is that they'll be able to bring their employees back for a week or a day at a time, or even a few hours each week on whatever work pattern suits the both of them. And then in the remainder of what would have been the employee's ordinary working time, they can continue to be on furlough leave, and the employer can continue to claim reimbursement of a proportion of their wages for that time. You don't have to do this. If you prefer, you can just continue to keep your employees furloughed full time. If you do that, then provided you've got written furlough agreements with your employees already, you don't need to change anything. You don't need to have a new agreement with them now, provided those original furlough agreements allow you to extend it beyond the 1st of July. You don't need any further agreement. If, however, you're intending to take advantage of the new flexible working scheme, or new flexible furlough scheme, then you will need a new agreement with your employees. It remains the case that during the hours or days when your employees are furloughed, they won't be allowed to carry out any work for you at all. They will be allowed to take part in training. That doesn't have to be mandatory training. I've had a few clients asking me, how mandatory does training have to be in order for us to ask our employees to do it whilst they're furloughed. The answer is it doesn't have to be particularly mandatory training. Any training that helps them to do their job, you can ask them to do during a period when they're furloughed, provided it's not doing something that makes you money or provides you with services. So yeah, by all means, ask your employees to do any training, and when they're doing their training, they can continue to be on furlough leave and continue to just receive furlough pay. But you can't ask them to do any work. If you are one of those naughty employers that does ask your employees to do work, and I'm sure nobody on this seminar or this call is one of those employers, but it's surprising how many there appear to be. If you do ask your employees to do work whilst they're furloughed, then at best what that could mean is that HMRC will claim back money when all this is over and they do their series of audits. At worst, it is potentially a criminal offence, and it can lead to a prison sentence of up to 10 years. Now, given that level of sanction, it's surprising how many employers seem to be flouting this at the moment and sort of making up their own rules. Estate agents seem particularly keen on this, furloughing their employees but then requiring them to do work anyway. It is quite serious, and HMRC have made it very clear that they are going to look at this when it's all over, and potentially they are going to impose some sanctions. Precisely what constitutes work or services is not defined. So there might be some employers who are innocently stepping over the line. We tend to advise employers to err on the side of caution on this. Asking employees to periodically read emails to update them on the current situation in the workplace, that's probably okay. Inviting them to attend purely social Zoom calls just to keep in touch with their colleagues, that's okay. Asking them to respond to emails or even forward on emails that they think are important and need to be dealt with, or to engage in work meetings, I don't think you can really get away with that. That sounds very much like work, and I think potentially that's the sort of thing that HMRC could crack down on. The scheme is now closed to new entrants. As of the 1st of July, you won't be able to furlough anybody who hasn't at some point in the past been furloughed for at least 3 consecutive weeks. The exception to that is if it's somebody who's returning from maternity leave or some other statutory form of leave. As I say, if after that you want to take advantage of this new flexible furlough scheme, you're going to have to agree that in writing with your employees. Now, as before, as with the previous scheme, the government has made it clear that usual contractual rules apply. This new flexible furlough scheme doesn't give employers some sort of right to impose flexible working on their employees. And usually, if you were asking your employees to sign up to some completely new working pattern, working 3 days a week rather than 5, or working half days rather than full days, you'd have to consult with them and possibly even consult with employee representatives and carry out a period of collective consultation. You might even have to dismiss a few employees and offer them re-engagement on new terms. In theory, that's still the case. You're asking your employees to agree something entirely new. You can't just require them to do so and insist on their agreement. That said, in the circumstances, provided you make it clear that the change is temporary, and given that the alternative is potentially coming back to work and working full time, and or alternatively being made redundant, hopefully most employees will agree to this. Hopefully most of them will agree to work flexibly and come back to work flexibly, and therefore will sign up to this new agreement when you send it to them. I would imagine that most of you already have, or certainly everybody who's currently using the furlough scheme already has a written agreement with your employees about furlough leave and furlough pay. If that's the case, then I think all you really need at this stage is some sort of variation letter, a kind of fairly brief side letter to go alongside your existing furlough agreement. We've drafted something fairly simple. Anna, I don't know if you're able to share it or whether I'm able to share it.
Yeah, let me try. Let me see if I can bring this up. Can everybody see that? Is that,
A few thumbs up?
Yeah, can you see that, Dan? Yeah, good.
Perfect, perfect, great, thank you. Okay, so these notes will be sent to you after the session as well, so don't worry about sort of trying to scribble all this down. But I think this is really as much as you'll need. So a sort of opening paragraph, updating them on the current situation with the business, introducing the fact that flexible furlough has now been introduced. And in light of that, telling them that you're asking them to vary the terms of the furlough agreement with you. and saying from the 1st of July, we may require you to work some hours in each week and then be furloughed for the remainder of the week, or we may require you to work for 1 week at a time. Where possible, we'll notify you of the hours we want you to work at least a week in advance. In theory, under the new rules, you're supposed to agree at the outset, or you're supposed to agree in writing, what hours employees will be working. In practice, I think probably most employers, or certainly a lot of employers, are going to want to do this on a kind of suck it and see basis. So maybe for the first week, we'll have you back 1 day a week. Maybe in the second week, it might be 2 days a week. After that, it might be half days, whatever. Let's assess it on a week-to-week basis, see where we are with work, see how many hours we can actually provide for you each week and usefully have you employed for. And then we'll let you know how many hours we want you to work. And that's fine. That's fine. Provided that in this written agreement that you send employees at the outset, you tell them what and how you're going to be advising them of their hours week to week. And you make sure that you're asking them to agree those hours on a week-to-week basis. A bit of a sting in the tail, you could say refusal to work those hours that we've asked you to work may be regarded as a disciplinary offence. There's a lot of ifs in that word may. There can be various dangers to disciplining employees for refusing to work in the current circumstances. Certainly an employee who said, I don't want to work because I don't think it's safe to do so, or an employee who said, I am unable to work because I've got an underlying medical condition which is a disability, or even an employee who said, very sorry, but I can't work because I've got childcare commitments because all the schools are currently closed, would have a level of protection. And it would be dangerous to say, well, in that case, we're disciplining you or sacking you for your refusal to work. But I think it's reasonable to put the sting in the tail here of saying it may be regarded as a disciplinary offence. You then go on to tell them that they will be paid their normal pay rates for any hours that they do work. That's important. The government is not offering to pay your employees' wages for you. During the hours when employees actually work, you're the one who's going to be paying them, and you're going to have to be paying them at 100% of their salary unless you've agreed anything to the contrary with them. The part that the government is offering to pay is the remainder of the week when they continue to be furloughed. All right. And so it says in this agreement, during the remainder of the week, you'll remain on furlough leave subject to the terms of our existing furlough agreement, including in relation to pay and benefits. Because it's during that other part of the week when they're furloughed that they're going to continue to get the 80% of pay, and you're going to continue to claim that back from the government. You then ask your employees to confirm that they've received the letter and that they agree to the revised terms. As I say, you do now need agreement from employees. That doesn't mean they have to actually put a signature on a piece of paper and send it back into the post to you, but it does mean that you're going to need at the very least an email exchange setting out that they have agreed, and then going on to say that you can, as before, terminate the existing furlough agreement if they don't agree. So if you don't agree to this, we may terminate the existing furlough agreement, bring you back to work, and or decide what steps to take next in relation to your employment. So again, that's the sting in the tail. We want you to agree, we'd like you to agree, but if you don't, you can't necessarily guarantee that the status quo is going to continue. We can't necessarily guarantee that you're going to just remain on furlough leave. It might be that we call you back to work 100% of the time, as we'll have the power to do. Or it might be that we'll make you redundant. Again, the key word there is might, and there's various risks if you do that. But that's the basis of the agreement that you're now asking them to agree. It's a temporary change. It's a temporary change to flexible working, reduced part-time working. And if they don't agree to it, then the alternative is potentially that you just take them off furlough and then decide what steps to take after that. Okay, Anna, that's great. Thank you.
Brilliant. Thank you.
You'll need to retain copies of that written agreement and your employee's response to that written agreement for at least 5 years. You also have to keep the exchanges that you have with your employees week to week in which they agree their hours. You'll need to keep those for 6 years, funnily enough. And you also need to keep a record of the hours that your employees work and the hours for which they're furloughed week to week. And again, you need to keep that for 6 years. And the reason you need to keep those is because, again, when HMRC does the audit that it's been promising, it's going to be looking for evidence that your employees agreed to this flexible furlough scheme and evidence that they agreed to the particular working pattern and hours and evidence that they did work those particular hours rather than some other set of hours or potentially worked full time for you whilst you were claiming reimbursement. The new scheme direction from HMRC came out quite late on Friday. It's 30 pages long. It's, like most HMRC documents, utterly impenetrable, but it largely replicates what we already knew from the guidance that had already been published. And one of the slightly surprising things is that after the 1st of July, your claim periods will no longer be able to cross over 2 calendar months. So you wouldn't, for example, be able to make a furlough claim for reimbursement to the government that covers the period 15th of July to the 15th of August, for example. What you'd have to do instead is make one claim for July and a separate claim for August. So what that means, of course, is that your claim period can only be a maximum of 1 month. It also says, though, that claim periods have to be at least 1 week. So even if you only furlough one employee for 1 day, you'll have to make a claim covering 7 days. So again, claim periods will have to be somewhere between 1 week and 1 month. Now that's relevant for the next point, which is this. In any one claim period, the maximum number of employees that you're going to be allowed to claim for won't be allowed to exceed the maximum number of people that you've claimed for in any period prior to the 30th of June. In other words, if you've only ever had 5 employees on furlough leave at a time up to now, you probably won't be able to put more than 5 employees on flexible furlough after the 1st of July. For lots of employers, they might be thinking, well, that makes absolutely no difference to me. I've furloughed all my employees and I'm going to have all of them back on flexible furlough, or some of them back, so that's no bother. It might, however, affect some employers who have been rotating employees on furlough. So for example, if you've got an employer that has said, right, well, in 1 month, we'll furlough 3 employees, and in the next month, we'll furlough a different 3 employees, and so on. Those employers won't be able to have everybody back on flexible furlough at the same time. They would only be able to have, in that case, 3 employees on flexible furlough at the same time. The reason for all these sort of odd rules is clear. I mean, it's the same as the one about saying that the scheme's closed to new entrants. You can imagine there's probably an awful lot of employers who are currently thinking, well, I couldn't really afford to have my employees out of the workplace for 3 weeks at a time, but I could definitely do with my employees going down to, say, 4 days a week at the moment. And I'd really like actually all my employees to go down to 4 days a week. So let's try and claim flexible furlough for all of our employees. And the government clearly wants to avoid that from happening. This is an incredibly expensive scheme for the government. It doesn't want to find itself having a whole load of new applicants and a new load of employees added to it. Another sort of slight technicality within the new rules is that only 1 claim can be made per PAYE scheme to cover any 1 claim period. Now, what that means is that you won't be able to submit different claims for different groups of employees. So for example, if you've got a London office and a Manchester office, but they're both on the same PAYE scheme, you wouldn't be able to say to your London payroll people, right, you make your claim, and then the Manchester people can make a separate claim, they would all have to go into one claim and be submitted all together. The maximum amount that you can claim as an employer is still 80% of an employee's normal pay, capped at £2,500 a month. That's the maximum you can claim based on that employee being furloughed 100% of the time during that month. Any hours or days that that employee works for you is deducted from that. Okay? Now, what that means is that you are going to have to calculate that balance. So you're going to have to be able to say, well, normally my employer would work 25 days a month. This month they've worked 20 days, and therefore they were furloughed for the balance, which is 5 days. So therefore I'm going to make a claim for 5 days furlough pay. Now, put in those terms of a calculation of 20 minus 5, even I as a lawyer can manage that, and that's okay. Actually though, the basis for calculating that balance, in other words, the amount that you can claim for employees who are flexibly furloughed, is amazingly complex. Many of the 30 pages of guidance in this new HMRC direction are devoted to what to me look like very scary formulas. It looks like A-level maths homework, frankly, of ways that you can calculate your employees' pay and your employees' hours and their furlough pay. The calculations are based on working out how many hours that employee would ordinarily have been working, which has to be based on their last pay period before the 19th of March if they're employees with fixed pay, or the same month in the previous year for employees whose pay varies, and then working out from that how many hours they've been furloughed in that same claim period. The reason it's so complicated, you sort of understand it, well, firstly, it's because accountants have got involved, but being slightly more charitable about it, the reason it's so complicated is because not all employees' work pattern is calculated over 1 week. Some shift employees, it might be over a 2-week pattern or a 3-week pattern or more. Not all months have the same number of weeks in them. Not all months have the same number of days in them. And that's why the calculation for working out what would an employee's normal hours have been in this claim period is quite complicated. In order to simplify things, the government has set out various worked examples on its .gov.uk guidance website. The simplest of these involves 10 stages. I have to say, if you're applying this to a number of employees at the same time, I imagine you're going to have to employ a full-time accountant in order to do it. However, 2 points. First of all, it is simplified if you can make your furlough claim periods match your usual pay periods. So if you usually pay monthly, if you can make your furlough claim periods monthly and covering the same period of time, then that simplifies things hugely. The other thing is that there is now a furlough pay calculator online, and if you use that, it does simplify things. It's much easier than trying to go through those formulas yourself. As I say, I think if you try to do those formulas yourself for every single one of your employees, and if you've got 10 employees, that's probably the only work you're going to be doing between now and the end of October when this scheme ends. Finally, before we open to questions, the scheme is gradually being tapered over the next few months. As of August 2020, employers are going to be required to pay their employees national insurance contributions and employer contributions on the furlough pay. Up to now, you've been able to claim that in reimbursement from the government. Then in September 2020, you're going to have to start paying 10% of your employees' salary, because the government's only going to be paying 70%, and you're going to have to top that up to 80%. And then in October 2020, again, the government reimbursement is going to drop again. It's going to drop to 60%, and you will have to top that up by 20% in order, again, to make the 80%. You can't just say, right, well, the government has started only paying 60%, so we're only going to pay our employees 60%. That's not allowed. You're going to have to top it up to the 80% if you want your employees to continue being furloughed. Now, because of these complications, because of the fact that the scheme is becoming less generous, and because many employers are now having a better idea of where they are in all of this and what's likely to happen over the next few months, a lot of employers' minds may have started turning to redundancy and thinking, well, rather than furlough employees, we think we're probably at a stage now where we're going to have to start making redundancies. What is absolutely clear is that you can carry out a redundancy consultation process at the same time as employees are furloughed. That's perfectly acceptable. The chances are that some of your employees are going to cry foul and say, well, why are you making me redundant at a time when the government is offering to protect my salary and protect my job? Is that not going to make my dismissal unfair? It's a factor. It's certainly a factor that tribunals would look at if an employee went on to claim unfair dismissal. But I think provided you can say, we're fairly confident that nothing much is going to change by October, and therefore we're in a position to start the redundancies now rather than waiting until October, I think it's highly unlikely to make the decision unfair. One thing that redundancy and unfair dismissal case law has taught us is that tribunals are not willing or able to say that a particular business decision is a bad one or that they'd have made a different business decision. Employers are entitled to make bad business decisions, and provided you can show why you've made the decision to make the roles redundant now rather than wait till the end of the furlough scheme, and provided you can show that you've consulted and done all the things that you're supposed to in a fair redundancy process, you should be fine in making redundancies at this stage. So those are the points I wanted to make about flexible furlough. Does anybody have any particular questions?
I think there's been quite a few questions coming through on the chat, Dan, so maybe we'll start there because I can't see anybody's hand raised at the moment. So the first question that was asked was from Will. For the flexible furlough scheme, does a salary cut for an employee prevent flexible furloughing as it had been done for the 3-week furlough scheme? So I don't know if Will, if you wanted to add anything further onto that.
No, it's just a double check really, because previously if you wanted to furlough someone, you couldn't do if they'd taken a salary cut or their pay had been reduced. But I don't know if that still applies for the part-time flexible furlough scheme.
Why couldn't you if their pay had been reduced?
That's what the guidance was for the previous furlough scheme up to the end of June, that you couldn't furlough someone if their salary had been reduced.
Okay, there were various complications in the previous scheme about where employees were on sabbatical and on nil pay. I think that might be what you mean. There was nothing about if their salary had been reduced.
Okay, well, we thought there had been. So
no, what you weren't able to do is take an employee who had already agreed to, as I say, go on something like a sabbatical and was on nil pay, or say somebody who was on long-term sick leave and on nil pay and furlough them. That was certainly true. Right. And somebody couldn't be on reduced sick pay and on furlough at the same time. You couldn't do the two together. But no, I mean, other than the fact that employees would be unlikely to agree to both at the same time, there was nothing to say that you couldn't go to an employee and say, right, I want you to take a 10% pay cut and at the same time, we'd like you to go on furlough leave. There was no rule on that. And their furlough pay would always be based on the pay that they had prior to the 19th of March. So I think, I don't know where you've got that idea from, but it's certainly not something that I'm familiar with.
Okay.
All right.
And the next question from Matt is one about how does this new flexible furlough scheme apply to those that already have flexible hours contract?
Yeah, good question. So again, your hours and your pay are based on the hours and pay that you had prior to the 19th of March 2020. In the case of somebody who has regular hours and pay every month, it's just literally the last pay period prior to 19th of March 2020. So for most people, that would be your February pay slip. For those who have variable hours and variable pay every month, what you do is you look at the corresponding month in the year before. So when you're calculating their July flexible furlough hours and flexible furlough pay, you would look at their July 2019 pay slip. So for somebody who's already reduced their hours down to flexible hours and flexible pay, or reduced hours and reduced pay, that's going to have an effect on their furlough pay and furlough salary. But again, as with the question to Will before, it doesn't prevent you from furloughing them. But what it does mean is that you couldn't sort of pretend that they were previously a 100% full-timer and in some ways sort of therefore claim reimbursement from the government for hours that they were never working anyway.
Okay, thank you.
You're welcome, Matt. Joe has asked whether staff can come into work for staff meetings. Hello.
Yeah, it's a very good question. As I said earlier, I would err on the side of caution as far as staff meetings are concerned. A meeting sounds to me like a service. Now, I accept that there is a grey area, because I did say earlier, I think asking employees to occasionally check their emails and see updates in the workplace is okay. But of course, checking for an update is something that you can do in your own time. You can do it whenever you like. Whereas attending a meeting is at a specific time, and you are asking your employees to be available at a specific time. Now, if the meeting is to discuss their redundancy, funnily enough, that's okay, and that's allowed for in the guidance. But if it's a sort of work meeting to discuss work-related issues, I would struggle to say that's not work. Now, if the employee is relatively senior, they're probably not going to be the sort of employee that then goes and grasses you up to the HMRC and says, my employer's been requiring me to work and it's all very unfair and you should send them to prison. But HMRC is going to do checks afterwards. And if they can see evidence that staff have been required to attend meetings, I think there's a risk that they might say that is work. Now, even before the flexible furlough scheme comes in, although there's a minimum amount of time that employees can be furloughed, you have to be furloughed for a minimum of 3 weeks. There is no minimum amount of time for which an employee can be unfurloughed. What I mean by that is an employee could be furloughed for 3 weeks, and then you could have them back for 1 day or half a day or even an hour to attend a meeting, and then you could furlough them again for another 3 weeks. So I think probably rather than take the risk, I would tend to err on the side of saying the meeting is work. You will be unfurloughed for that meeting and we'll pay you 100% of your salary, and we'll pay it rather than reclaim it from the government for the period of that meeting. And then we'll furlough you again afterwards. That will be made even easier after July, because of course, then you can say come in for 1 meeting a week and we'll furlough you for the rest of the week. And that will be absolutely fine.
That sounds the most sensible approach to me. Definitely paying for that employee to come in for that 1 day. There's another question here from Samantha regarding that their furlough agreement doesn't have an an end date. It's just until further notice. So is there a requirement to do anything from the 1st of July, especially if they're looking at the flexible furlough leave and given the template that you just shared with everyone?
If they're looking to do flexible furlough, then they'll need to send their employees something new agreeing flexible furlough. As I say, that side letter I think should suffice for most employers. If you're looking to just keep your employees on 100% furlough leave, I don't think you need anything new. You've just said your existing flexible furlough agreement had no end date. So if it has no end date, then it follows that you're perfectly entitled to keep it going into July, August, September, October, if that's what you choose to do. I would say, in the spirit of sort of openness and keeping communication channels open with your employees, it would be reasonable to send them at the very least an email or a letter saying, hello, hope you're still okay. We've decided to keep you on 100% furlough. We'll let you know if that changes. I think that would be a reasonable thing to do. But no, if you're just looking to keep the status quo, you don't need anything new in new agreement in writing with your employees.
Karen has asked as well that there was someone on furlough leave in April. It was more than 3 weeks, but they've been working since that. And now they want to go down the flexible furlough leave. Would that be okay?
Yes, that'll be absolutely fine. Yeah, there was a lot of talk and a lot of misunderstanding when the guidance first came out of employers thinking that they absolutely had to have their employees furloughed on the 10th of June or absolutely had to have their employees furloughed on the 30th of June in order to keep taking advantage of the furlough scheme. Not true at all. That's not how it works. All the government was saying is, in order to take advantage of the new scheme after the 1st of July, you have to be an employee who has been furloughed at some point in the past for at least 3 weeks. And as I said earlier, the reason for that is quite obvious. The government didn't want a load of employers suddenly thinking, well, great, flexible furlough sounds much better than regular furlough. Let's put all our employees on flexible furlough and the government finding itself inundated with new claims.
I'm going to ask Amanda if she'd like to come in with her question, because I know it's quite a complex one and it was all to do with the number of flexible furlough employees you can claim for in July. So Amanda, would you like to ask this question directly to Dan?
Oh, lovely. Thank you. Dan, we haven't actually furloughed very many people. We're about 6 or 7 weeks behind the rest of the UK. So what my question is if, for example, in April or May, or the June one is probably the one to talk about, we only furloughed 3 employees, but in July, we want to furlough 6, but they were alternate weeks. So 3 were working 1 week and 3 were working another week. In total, we only claim for 3, if that makes sense.
Yeah,
So,
yeah, no, it does make sense. It's quite a specific question. Briefly, as I said earlier, you can't claim for more in any one claim period post the 1st of July. You can't claim for more employees on furlough than you had in any one claim period up to the 30th of June. Now, in your case, that would mean that if you've only had 3 on furlough at any one time, you wouldn't be able to just put in a claim covering the whole of July saying, here's the 6 employees that we've had on furlough in July. That wouldn't be allowed. That would be rejected because that's more employees than you've had on furlough at a time. But as I said, your claim period can be anything between 1 week and 1 month. So if you're saying that if you're going to go from week to week, then
yes.
What that probably means is you're going to have to put in different claims for each week.
Right.
So you put in a claim for the first week of these 3 employees,
yeah,
and then another claim for the second week for the next lot of 3 employees.
Okay, that makes sense. Yeah.
So you're splitting it down into smaller claim periods.
Oh, okay. No, that's lovely. Thank you.
Okay.
Thank you.
Nigel's asked a question here about, can you add new employees to the furlough if you're bringing back people? I understood that my understanding, Dan, was that the cutoff for anyone going on furlough was like the 10th of June. And then after that, you couldn't furlough anybody else. So He's asking if you can add new employees if you're bringing back people, i.e. as long as the total number isn't exceeded. Can we add new people?
I don't know what he means by bringing back people. I don't know if Nigel's here and will be able to clarify that.
Hello, sorry, yes, can you hear me? Apologies, yes. That was bad typing, apologies. No, basically, we've had a number of people, I think in a similar way to quite a few discussions, where we've had people coming on and off furlough, but what we now have is a slightly different situation where we're training a number of people, and we're just wondering that even though they haven't been furloughed up to now, if we're bringing other people back to undertake the role that they were doing, so these people could be going on to training, would we be able to swap over the furlough in that way?
No, sadly not, I'm afraid.
Okay.
Yeah, that does sort of make sense. But no, the rules are very specifically, you will only be allowed to furlough somebody who previously has been furloughed.
Indeed. Okay, that's what we thought, but worth a try. Thank you.
Indeed, indeed. If they have very similar names, you might get away with it. But if that happens, then I certainly never advise you to do it, and I'm not going to come and visit you in prison.
Okay, thank you.
Angela's asked a question: if sales have dropped enough for them not to need one person, do they have to wait until the end of October to make them redundant? Well, my understanding is that you can go through the consultation process now, isn't it? Is that right, Dan?
Yes, I think what Amanda's, sorry, who's the question from?
It's from Angela.
Angela, sorry. I think what Angela is saying is it touches on that point that I made towards the end, that a lot of employees are suggesting at the moment, and certainly trade unions are suggesting at the moment, that if an employer has the temerity to make anybody redundant, that the employee would have some sort of unlosable unfair dismissal claim, on the basis that how can it possibly be fair to dismiss somebody on the grounds of redundancy during a period when the government furlough scheme is still in place and the government's offering to pay a proportion of employees' wages. I don't think that can be right. I mean, as I said earlier, it would go into the mix. The test in an unfair dismissal case was what the employer did reasonable in all the circumstances? And all the circumstances at the moment includes, you've probably got a fair idea of where your business is going to be by the end of October. The furlough scheme is becoming a lot less generous. It always has been the case that furloughing employees costs you something because they continue to accrue holiday. And of course, you've also got the administrative burden of making a claim for them month to month. And therefore, if putting all those things into the mix, your business decision is, well, we could wait to the end of October, but we are now in a position where we know we're going to need to make redundancies at the end of October, then I think you actually also have a potentially slightly pious argument, but a bit of a moral argument to say it would be wrong of us to take advantage of the government scheme, which is after all designed to protect employees against redundancy, in order to keep on an employee that we know full well we're going to make redundant when this scheme ends. And therefore, in those circumstances, you already know sales have dropped to that level. You already know you're going to have to make them redundant, or you're almost certainly going to have to make them redundant. I think if you decide to make them redundant now, I think an employee would struggle to say that that was unfair.
I've got Lorraine asking, what is the minimum furlough period from the 1st of July? Is it now a week?
No, not at all. And there is no minimum furlough period after the 1st of July. So if you decided you could use your employees for all but 1 hour a week, then I guess you could furlough them for 1 hour a week.
Will just sent a link as well. It was to clarify his earlier question from HMRC guidance for claim periods up to the 30th of June. If an employee is working but on reduced hours or reduced pay, they will not be eligible for this scheme. I'm trying to think, Will.
That's if they're working. You can't claim. So yeah, that sort of was almost sort of looking ahead to flexible furlough. What that was saying is if your employee is doing work for you, they can't also be furloughed. Now, of course, now with the new flexible scheme, or as of the 1st of July, potentially they can work for you for part of the week and then be furloughed for the other part of the week. But no, what that wording meant was you can't at that time anyway, and right up to now, say, well, my employee is on a reduced salary of 50%, and I'm going to pay them 50% for doing 50% of the work, but then claim the other 50% through furlough. That's not been allowed, and that's what that wording meant in the old guidance.
Okay, thank you for clarifying that, Dan. And I've got one final question from Angela. What do you do if someone on furlough leave resigns? Can you put them back on furlough following having had them back at work for a handover?
If you want to, yeah. If you want to be mean, you can say, I'm not putting you on furlough and I want you to work out your notice. And if they refuse to do so, then you don't pay them their notice in the same way as you would be able to at any other time. But if you're happy to furlough them and they're happy to be furloughed, then yes, that's a perfectly reasonable way of ending your work relationship with them, of just putting them on furlough for the remainder of their notice period and paying them through furlough.
I'm not sure if we've got any other questions at all. I can't see any raised hands or any other questions coming through. It's been really informative and really useful, because I know the flexible furlough scheme is becoming ever more challenging and more complicated. And also in the next few months, it's going to be the employer that will have to pay more as well. So there's going to be some more challenges that we see coming about. But thank you so much for joining us today. We have got some other webinars, so please do continue to look on our website. We've got various other webinars happening, as well as online training. So if you do have staff on furlough leave, please do point them in the direction of Sussex Chamber, book them onto any of the training courses that we have that could help you carry on developing their skills whilst they're on furlough leave. But thank you very much, everyone, and thank you very much, Dan, for a very informative session today.
Thank you.